name is Mackay. I'm an attorney in Petaluma, California, and I practice in the area of wills, trusts, and estate planning. And this video blog is going to be about granny snatching. What is granny snatching? Well, essentially what it is, its negative form in a sense, is when you have an elder who is living in one state and maybe raised their children, grew up, and is in California, but has relatives in New Jersey. The relatives in California appeal for her or his guardianship and conservatorship, and they obtain that, but then the elder goes to visit the relatives in the other state, and they feel for whatever reason Granny's not being taken care of well enough, or they'd be happier with them, or Granny may even say that. And so they institute action to get a conservatorship for Granny in that state, and a fight ensues between the relatives interstate fighting over this elder. In the past, the problem has been is you have two different states' laws, and typically the state that originated the guardianship or the conservatorship loses and the new state takes over, because you can't physically order another state to transport, order people living in another state to transport Granny back. And 9 times out of 10, these grannies need a conservatorship, so they're not involved in this discussion, and they sort of are pawns in the fight of the family. There has been new law springing up over 31 different states. California is not one of them, but California is studying this law. And it's going to be, it's called a Uniform Adult Guardianship and Protective Proceedings Jurisdiction Act. And like all attorneys, it has an acronym because we love acronyms, us and government bureaucrats. It's UAGAPJA. UAGAPJA, something like that. It's long. What it does, anyways, is try and coordinate states' laws in guardianships for elders and conservatorships, which are basically the same thing, so that these fights that often drain the elders' resources because the relatives aren't paying for it. Typically, the cost of that comes out of the elders' assets, and it makes it so each state will recognize a conservatorship in another state. So, in other words, if California had it and Pennsylvania had it, and Granny went to Pennsylvania, those relatives decided that they wanted to have her, she would be better off there, and start a conservatorship there, it would be blocked because the law favors where the elder has residency, and let's see, it defines a home state, the state in which the elder was physically present for at least 6 consecutive months. That state would have primary jurisdiction over that elder. So in this way, it will reduce the number, hopefully, of fights between families over their grannies. And there won't be any of this kidnapping, essentially, of elders who don't have the capacity or ability to assert themselves about where they want to stay. California is studying it, started studying around February of 2011, and hopefully will be enacting it. So if you know any legislator out there in California that has this bill in front of them, or when the bill comes about, I will have another blog on it, you want to encourage them to vote for this because it helps our elders in our communities.